Good afternoon, all of you. Previous class under company law, first unit, we discussed about what is company mean, its historical meaning, general meaning, and company meaning as per Companies Act. And also discuss about the characteristics of company, lifting of corporate wealth, and kinds of companies. Right? So in today's class, we are going to discuss about incorporation of a company, memorandum and articles of association, important documents to be submitted at the time of incorporation of a company.
You've never seen me cry. Take the seat if somehow we've lost touch.
Your mic, I just.
Stay close.
Okay, so I'm sharing screen here to discuss our today's topic, incorporation of a company. At the end of this class, you'll be able to learn about what is procedure for incorporation of a company and what are the documents to be submitted, and analyzing the position of promoter, then understanding the essential documents to be submitted, what are the profit and loss, Memorandum of Association and Articles of Association, and their alteration. So we are going to discuss about these topics: incorporation, conclusion of certificate of incorporation, promoter of a company, legal position of promoter, Memorandum of Association, alteration, and Articles of Association, its alteration. See, any company, before it coming into existence, involves certain process. That process is incorporation. Means before it is formed, certain preliminary steps are to be undertaken, what is its name to be, and where it has to keep its registered office, what is the capital to be raised, and what is the liability of members to be made, whether it's a liability limited by shares or limited by guarantee. All these decisions has to be taken. These are all called preliminary steps. Once a company, once these all preliminary steps are taken, and necessary documents relating to these steps are prepared, the company has to get a legal identity registered with the registrar. That itself is the incorporation. Okay, so once it gets the identity separate from its members, we call it as a company is incorporated. And generally, all these preliminary steps, whatever are involved, are undertaken by a person called a promoter. The process of these preliminary steps, before the formation of a company, we call as a promotion. Okay, so I'll repeat once again. The process which involves in order to bring the company into existence is called a promotion, and the person who undertakes these preliminary steps for promotion of a company we call as a promoter. So here under this topic, we are going to discuss about what is incorporation of a company and what are the legal provisions to be followed, and then who is the promoter and his provisions relating to the incorporation of a company. So incorporation of a company, which is in simple to say registration of a company, means every company, whether it is a private limited company or a public limited company, has to get registered. That is, it has to be incorporated. Okay, whether it's a private company, public company, one person company, whatever it is, must get registered. Legal status of the company is important. Okay, so in order to get the company register, they are supposed to submit certain documents with the register of companies. So what are those documents? Memorandum of Association, which is to be signed by the members. The Articles of Association, which again signed by its members. List of directors who gave their consent to be directors of the company, and declaration stating that the company has followed all the declaration stating that company has followed all the provisions relating to the act in order to get incorporated. And finally, audit general or an advocate of Supreme Court or High Court has to sign this document, and a secretary also or a chartered accountant also has to sign this document. Okay. Yes. Section 2 or Section 7 of subsection 2 states that the registrar, on the basis of about documents and information, shall register all the documents and issue a certificate called Certificate of Incorporation. Is whatever the documents a company, these promoters submit for incorporation with the registrar by payment of a fee, registration fees. Then after submission of these all documents like memorandum, articles, and consent, written consent of directors, approval, consent of provisions followed for the incorporation, all these documents are submitted with the registration fee to the registrar by the promoter. Then the registrar will verify these documents. Will verify these documents and the provisions, the contents given in that. If all the correction, all documents, information is provided as per the provisions of the Act, then he will issue the, he'll enter the company name in the register of companies, joint stock companies, and issue a certificate called Certificate of Incorporation. That means with this Certificate of Incorporation, a company is said to be registered and got its legal identity separate from its members. It has its own legal existence. It gets its own legal existence and it gets separate from its members. And with this certificate, they can start their business. Generally, but here, public limited company need to wait. A private limited company, after obtaining this certificate of incorporation, can start its business. But public limited companies has to obtain one more certificate called Certificate of Commencement of Business. Why? Because private limited companies raise their capital among themselves. Right. So immediately after getting the certificate, the capitals are raised and the next procedure, whatever is that they can take care among themselves and they can start. But public limited company raise its capital from the public. So it needs to collect the capital. Minimum subscription has to be collected. Then only it can go for starting the business. Again, some procedures, legal procedures involves raising of capital. Again, submitting the details and the documents relating to the raising of capital. Then we will get a letter of commencement of business. So then only they can start. So certificate of incorporation, after getting this, private company can start. Yes. So this certificate of incorporation is said to be the conclusive evidence of that is given by the registrar. Why? Because registrar, before issuing this certificate of incorporation, will refer all the documents and see for their corrections. Like all these documents are there as per the provisions or not, and after thorough verification only, he will issue the certificate of incorporation. So this document is said to be an in conclusive evidence that is given by the registrar that all the requirements of the act have been compiled by the company in respect of the registration. Means in order to get a registration, whatever the legal formalities are required to be followed, all those are followed. That certificate indirectly says that. Okay, once you are getting a certificate, means see, if you get a certificate, a pass certificate of your degree, what does it mean? You have written your test and you completed all your papers generally, and you completed your course, right? Same way, no one can say, yeah, you did that. Same way here. Okay, so this certificate cannot be disputed on any ground. Okay, so once certificate of incorporation is received, means nothing can be inquired into that, whether the company is company relating to the company's procedures or regularities before its incorporation, because it is a conclusive evidence that is given by the registrar. So nobody can raise any disputes under any ground about the company proceedings prior to the incorporation. But in order to explain that how this certificate is treated as a conclusive evidence of conclusiveness of the evidence of a conclusive evidence that the requirements have been fulfilled by the company. This Jubilee Cotton Mills Limited versus Levy's case tells us. I'll show you here one YouTube video relating to this case study. This 4 minutes video, please watch. There are two promoters. Registrar of companies is going to register of companies. So Harry submitted. On 6th January. Sixth January. Okay. So what does this say? Oh, sorry. Let me close this. Right. So in this company, one of the promoter has issued the shares to the other one on 6th before the incorporation. Okay. Then they submitted the documents to the company registrar on 6th January, but the certificate has been issued on 8th January. But on the certificate, the dated as 6th January. So this as dated. This registrar himself dated it as the issue of certificate on 6th January. So whatever the shares issued to this partner promoter got valid. Okay, so next, promoter of a company. Sorry, this case. So what this case tells you? Certificate of incorporation is a conclusive evidence given by the registrar. Okay, so though actually they submitted on the 6th, but the registrar instead of 8th entered the date, issued the certificate on 8th, but he entered the date as 6th. So the issue of shares to the promoter has got valid. So this case tells us that whatever whether the date has been entered by the registrar, that's the final conclusion to make that company is legally came into existence. Now let us see about the promoter of a company. So who is the promoter of a company? A person who actively undertakes the person who actively undertakes all the activities or the procedures, legal procedures for bringing a company into existence. That person is said to be a promoter. So promotion of a company. See, look into the definitions that are given by Companies Act. Who has a control? A person who has a control over the affairs of the company directly or indirectly, whether as a shareholder, as a director, or otherwise, is said to be a promoter. Means who enters, who has a control over the company's functions, either as a shareholder or as a director or some other person. We call him as the promoter of the company. Or there is another definition also given by the same in Companies Act 2013. The promoter conceived the idea of forming the company and take necessary steps to incorporate the company. After the company gets incorporated, they hand over the control of the company to its directors. Generally, sometimes see other person who has knowledge of all the legal formalities and everything. I can take care of the documentation and all perfectly and can do. But I'm not investing in the company. I'm not going to do any investment in the company. So I'm just undertaking a part of promotion of a company, all the legal procedures. That then also I'll call as a promoter of the company. After once I complete all the legal procedures and company gets incorporated, I hand over the entire control to the directors of the company. Then also I will be called as I'll be called as a promoter. So in simple to say, a person who actively involves in the promotion of a company is called as a promoter of the company. So what are the legal provisions of, legal position of the promoter? What is the legal position of a promoter? See, as a promoter, I'm taking care of entire business getting into existence. So I do enter into the owners or the real owners, whoever are there, the people who are investing, kept their confidence on me and left everything or given me some powers. So, as a promoter, having the due powers and responsibility to deliver my duties, I have to some legal obligations. So, let us see that what are those. That is, as a promoter. A promoter is neither an agent nor a trustee of the company. So, a promoter is not to be treated as an agent or as a trustee. Then there are certain fiduciary duties imposed on him. What are those? First one, a promoter should not make any secret profit on the expenses that he spent for the company. That is, in order to bring a company into existence, for the in the process of incorporation of a company, outer expenses are incurred. He is not supposed to make any secret profits. Like say, incorporation of a company, documentation charges and all totally incur some 10,000. He cannot say that 12,000 incurred and 2,000 he keep in the pocket. That cannot be done because I already said he has a fiduciary position. He has a means the real owners, the people who are investing on the company, kept a lot of confidence on him and responsibility on him, trust on him. So he has to do his functions very with with a very responsible way in a trustworthy manner. So he should not make any secret profit from the expenses of the company and to give the benefit of negotiations to the company. He is try to, because see, whatever, whether I do or not, I'll get my commission, I'll get my salary, I'll get my share. It should not think like that. He should, as a promoter, he should think that as if it is his own business, he is doing for it. He should make all the necessary possible negotiations in order to reduce the cost of expenditure to the company, whatever he enters into the contracts or dealings. Next one, to make a full disclosure of interest or profit. See, if he has any interest or if he is making any profit, that has to be disclosed clearly to the members or the other investors or the persons who are investing in the company clearly. Say, for example, I have my own land. So for the company, I have to promoter. A promoter has his own land, and for company, also he need to acquire a land. So he can sell his land to company. He has a mind that is okay. I can outside market. This is the rate land is having. I'll charge some 2 lakhs extra, and I'll sell to company. Yes, he can, but he should disclose why he is showing interest in selling his land to the company, what profit he can making, and why, what is his interest in selling the land. That all has to be disclosed to the other concerned people, not to make unfair use of his position. So, being a promoter, he is in a very responsible position, and he has various duties to perform. So that should not be taken for personal use or using that position or power. It should not misuse for any other reasons. Okay, so these are the some legal positions of a promoter. One, he should not make any secret profit out of the expenses of the company, and he should always think about getting benefit to the company in whatever purchases he make, that is negotiations. Make full disclosure of interest or profit, if any his interest or profit he made, not to make unfair use of his position. Yes. The next one is preliminary contracts. What are the preliminary contracts? Before, as we discussed, a company, before getting into existence, that is getting its legal status of certificate of incorporation, it need to enter into certain contracts. like it has to acquire land or building for doing its business. It has to hire the people, so it may acquire, get the or enter into the contract with the suppliers to supply the material. He has to enter into contract with the suppliers to supply the machines required in the business. So these all are to be pre-arrangements before which a business come into existence. These contracts or pre-arrangements requiring the pre-arrangements or pre-contracts which are entered by the promoter for acquisition of land, property, or labor, whatever, said to be a preliminary contracts. Okay, these contracts are said to be preliminary contracts or pre-incorporation contracts. So these preliminary contracts, company is not liable in case anything happens. The company is not liable on the preliminary contracts, and such contracts are null and void. Because why? Promoter's responsibility. After the incorporation of the company, it cannot sue or be sued on such contracts. That's to be remembered. Preliminary contracts, because the entire responsibility is in the hands of the promoter. It spends everything. Whatever the contracts entered and agreed upon, negotiated upon, or all be paid by the company or the promoter on before the incorporation. So before incorporation, before its legal existence, whatever contracts are entered are not liable for those contracts. Means they pay. It doesn't mean that they will not pay. They just null and void. Means they'll pay, but any disputes, any differences cannot be entertained. Will not be entertained. Okay. That's the reason why the promoter has to be careful, and the suppliers who are entering into contracts with the company, as a preliminary contracts, to be careful enough. Next one is position of promoter with regard to preliminary contracts. I said na, so because he's the responsibility, sir. Personal liability. A company after its incorporation, as we discussed just now, bound to preliminary contracts has no obligation, and these are null and void. So obtains the benefit out of such contracts. The promoter remains personally liable. Understood? Promoter is personally liable for such contracts, and he is deemed to be the person who is responsible for any differences that arises in the contract. So, okay. See, even in our surroundings, we used to observe. See, you want to start, you as a person, say your known person said, I want to start some coaching center, one room, I need, okay, I want to start a coaching center. And he don't know anyone in the city. So you said, I know my friend who is having a good space, good office place for opening a coaching center. I'll talk to him, and you talk to your friend and gave the office space for him. And your friend doesn't know this third person who is going to start. He gave you the room, office space, looking at you, means with the trust on you. Right. So after starting the business, if he says your rent is not paid, who will ask? See, before but instead of on January, he joined from the March. So 2 months rent, who will pay? If your friend didn't come. On March also he didn't come. January, February month, rent, who will responsible? You responsible, because third party didn't come, so your friend asked you. Same way here also, a company after incorporation is not bound by preliminary contracts. Okay, and anything relating to the preliminary contracts are null and void. So even though this means from these preliminary contracts, even if the company gets benefits, these contracts not company is not liable to these contracts. Then who is liable? Promoter is personally liable and deemed to be entered because he is the one who entered into the contracts personally. Again, this case has been explained with this Kelliver and Baxter. This is some 5 minutes video. YouTube link didn't come. We'll read it later. You can take the printout, screenshot of it, and you can watch this video later. There's hyperlink not covered on this. The next one is position of promoters with regard to preliminary contracts. What is this position? No ratification means a company cannot ratify preliminary contracts in order to exempt his personal liability on such contracts. What is this? Okay, I'm sorry for the mistake, sir. So, no ratification means upon preliminary contracts, whatever his liability is there, in order to exempt his liabilities, he cannot change the contracts. Okay. So that is what no ratification. Ratification means he cannot make any changes. He cannot make any adjustments. A company cannot ratify preliminary contracts in order to exempt his personal liability on such contracts. The firm may provide that. I'm sorry. A company cannot ratify and they cannot certify. First one is the company makes a fresh contract in place of pre-incorporation contract and his liability comes to an end. If the company does not make a fresh contract within a limited time, either of the parties may resign the contract. Okay. The company cannot ratify preliminary contracts in order to exempt his personal liability on such contracts. In order to exempt his personal liability. అంటే మన ఈ ప్రమోటర్ యొక్క పర్సనల్ లయబిలిటీని తప్పించడం కోసం కంపెనీ ఈ కాంట్రాక్ట్స్ ని ప్రిలిమినరీ కాంట్రాక్ట్స్ ని ఏ విధంగా రాటిఫై చేయడానికి లేదనమాట. ఓకే. నెక్స్ట్ వన్ ఈజ్ ఎలాంటి సందర్భాల్లో అంటే కొత్త కాంట్రాక్ట్స్ ప్రిలిమినరీ కాంట్రాక్ట్స్ ముందు ఉన్న వాటిని ఫ్రెష్ కాంట్రాక్ట్స్ ఇన్ ప్లేస్ ఆఫ్ ఇన్కార్పొరేషన్. ఒకవేళ కంపెనీ ఈ ప్రిలిమినరీ కాంట్రాక్ట్స్ నుంచి ఎగ్జిట్ అయిపోయి ఫ్రెష్ కాంట్రాక్ట్స్ చేయడం అలాంటివి చేసింది అనుకోండి, అతని లయబిలిటీని క్లోజ్ చేయడం లాంటిది. లేదా కంపెనీ ఫ్రెష్ కాంట్రాక్ట్స్ విత్ ఇన్ ద లిమిటెడ్ టైం చేయకుండా either of the parties may resign the contract. The company does not make a fresh contract within a limited time, then also send. So ఏ విధంగా కూడా ఈ ప్రమోటర్ ని సేవ్ చేయడం కోసము కంపెనీ ఈ ప్రిలిమినరీ కాంట్రాక్ట్స్ ని రాటిఫై చేయడానికి లేదు. The next, provisional contracts refers to the contracts entered into. This is over. I'm sorry. So these are the two situations where promoter is regarded, position of promoter with regard to preliminary contracts. I'll repeat once again these two. Position of promoter. From here, I'm coming back again. What is who is a promoter? A person who has a full control over the affairs of the company. He can be a director or a shareholder or an other person. Generally, a promoter will give you an idea right from the idea of a business till its incorporation. He involves in the business, and he handed over the control of the business to the directors. Okay, so a person who involves from revelation idea to incorporation of a company, we call as a promoter. Then this promoter has some legal position because he's the one who takes care of entire business, means getting into the existence. So he possesses some fiduciary position. What are that? He is not supposed to make any secret profit out of the expenses of company, and he, if any benefit, he should try to make a benefit to the company by his negotiations at the time of purchases. And next, he should make a full disclosure of his interest or profit, if any. Next, he cannot make any unfair use of his position. Next, relating to the preliminary, again, legal position of a promoter relating to the preliminary contracts. Before we talk about that, we are supposed to understand what are preliminary contracts. Preliminary contracts are those contracts which are entered by the promoter before the incorporation of a company in order to acquire some property or some properties. Okay. So generally, these for these, in case of these preliminary contracts, company has no liability at all. These contracts are null and void. Okay, so company cannot sue upon these. A company, a preliminary contracts later means after incorporation, whoever are under these preliminary contracts cannot sue the company, because these preliminary contracts are those contracts which are entered before the incorporation. So they are for those contracts, company is not liable. Any liability arises for the company only after incorporation, right? So then what about the contractors who entered into contract with this promoter? So there arises the promoter's responsibility. So what is that? First one is personal liable. Who is liable personally? Promoter, because company is not liable for the preliminary contracts, right? So then who is liable? The promoter is liable for the preliminary contracts that are entered by him, and these contracts are deemed to be entered into by him personally. Okay, so company will not pay on these. Only the promoter is responsible for the any disputes of the preliminary contracts. The next one is, and company cannot ratify these contracts in order to save the promoter. Company cannot ratify the contracts in order to save the promoter. Like how company ratifies means entering into a new contracts instead of preliminary contracts. Okay. Because if I enter into the new contracts and ignore the preliminary contracts, this liability of the promoter come to an end. So it should not do that. The next one is, if company does not make a fresh contract within the limited time with the promoter, with the preliminary contractors, both the parties may stop. Then also the promoter's liability comes to an end. So these kind of authorized valid way of formal consent should not be given. Okay. And next, after that preliminary contracts, next one is provisional contracts. What are the provisional contracts? Those are preliminary contracts, right? Preliminary contracts. The next one is provisional contracts. What are provisional contracts means? Provisional contracts refers to contracts entered into by a public company after its incorporation, but before issued of certificate of commencement of business. Okay. So provisional contract means these are the contracts which are entered after incorporation and before commencement, especially by the public limited company. Because for private limited company, after incorporation, they can start immediately. Okay, so they will not have these provisional contracts. So provisional contracts, any contract we say as a provisional shall not be binding on the company until the date, and on the date shall become a binding. So ఇది మనకి మన పబ్లిక్ లిమిటెడ్ కంపెనీస్ విషయంలో, ప్రైవేట్ లిమిటెడ్ కంపెనీస్ విషయంలోనో వాటిని ప్రిలిమినరీ కాంట్రాక్ట్స్ అంటాము. ప్రమోటర్ ఒక రెస్పాన్సిబిలిటీ, కంపెనీకి ఎలాంటి బైండింగ్ ఉండదు. ఆ తర్వాత ఆఫ్టర్ ఇన్కార్పొరేషన్ నుంచి వాట్ ఎవర్ ద కాంట్రాక్ట్స్ ఆర్ ఎంటర్డ్ ఫర్ ఆల్ దోస్ కంపెనీస్ లయబుల్. వాట్ అబౌట్ పబ్లిక్ లిమిటెడ్ కంపెనీ? పబ్లిక్ లిమిటెడ్ కంపెనీస్కి వచ్చేసరికి provisional contracts అంటాము. అంటే the contracts, because public limited companies start their business after getting the commencement of business. Okay, they get two certificates. So after issuing the certificate of incorporation, before issue of a public commencement of business, whatever contracts are entered by the public companies, those we call as the provisional contracts. So in case of these provisional contracts, again, company is not binding and no, these are void till they get a commencement of business. So if they don't get any commencement of business due to any reasons, these all provisional contracts automatically lapses. That's about incorporation of a company. Do you have any doubts, children? Any doubts? Yeah. Now let us see our next topic. I'm going to take next topic, our Unit 3, Memorandum of Association and Articles of Association. So we discussed that at the time of incorporation of a company, promoter has to submit certain documents with the registrar. Under that documentation of incorporation of a company, important documents we discussed: Memorandum of Association and Articles of Association, right? So let us see what are these Memorandum of Association and Articles of Association. This is the Unit 3 of our topic. Yes, memorandum means what? It's a primary document originally formed by the company. Time to time, based on the requirement, company will make a alteration in this. Generally, this document we say it's a fundamental document of the company, and why we say it is a fundamental document of the company? Because this document tells about the entire company to the outsiders. Means relating to the information, the main information that is required by the outside world, all that the information is given in this document. The company powers and its relationship with the outside world is explained under this Memorandum of Association. Okay. So why this information and why this document? Because the very purpose of this document is to enable the shareholders, its shareholders, creditors, and whoever dealing with the company should have a complete knowledge and know the activities of the business. So let us discuss about this document and its contents in it. In simple to say, this Memorandum of Association means, according to the Companies Act, Memorandum of Association means the company as originally framed and altered from time to time in pursuance of any previous law of this Act. So it is first step in the formation of a company. It sets out the constitution of the company, that the powers and relationship of company with the outside world. Then that is the reason why we call it as a fundamental document of the company, and every aspect of company structure and functioning is based on this document only. How the company has to function, what is its structure, everything goes based on this information given in this document only. That's the reason why we also call this as the basic fundamental document or charter of company. Okay, it has the utmost importance, and this document has to be prepared with utmost care also. Any correction, any errors in this document and corrections in this document after incorporation involves alteration of this document, involves huge expenditure. That is very expensive. That is the reason why. And being a fundamental document, and the entire functioning and structure of the company depends on this document. It has to be prepared with very utmost care and attention. Okay, and that is this document has to be printed and the information in this document has to be divided into various paragraphs and numbered consecutively. Means number in a serial number, each of the paragraph has to be given, and it should not be in points, or it should not be like a just phrases. It should be in a paragraphs. Okay, and after completion of this memorandum of the contents of the information through various contents in the memorandum, this document has to be signed by 2 subscribers. If in case of private company, and 7 in case of public company. Anyway, for the one person company, 1 person. Okay. So let us see about the contents of memorandum of association. So what is memorandum? It's a fundamental document. It tells it's a constitution of a company. It tells the powers and the relationship powers of the company and relationship of company with the outside world. So it has it is basic document on which entire company structure and functioning depends. That is the reason why we call it as a charter of company. It has to be prepared with utmost care and attention, and must be in writing, divided into paragraphs, numbered consecutively, and must be signed by the 2 subscribers in case of private, and 7 in case of public, and 1 in case of 1 person company. So let us look into the contents of memorandum. The alteration of memorandum is very expensive, so while preparing this document, it has to be very careful. So let us, what are the contents? Name clause. This content includes the details relating to the name of the company. The next one is situation clause. Situation clause means states in which the registered office of the company located and under which jurisdiction it comes. The third one is object clause. This is the very important clause which tells about the objectives upon which company is going to function or proposed for the registration. With what objects it started its business. The next one is liability clause. Under this clause, it mentions about the liability of its members, whether the liability of members is limited by shares or limited by guarantee. The next, share capital clause. Capital clause means the amount of capital. It tells about the details relating to the capital of the company. The next, agreement among the members of company. Like after this memorandum, it is because see, someone after some company is going to continue for a long time. It's official person. Okay, and no the joining or the death insolvency of any member will not affect the company. But the people who made this document may or may not be. Right. So in order to avoid these problems in future, disputes in future, this agreement, whoever the people involved in writing of the memorandum or preparation of memorandum has to sign. So the details of those people are there in the 6th document. Let us see about these contents in detail one by one. This is for our information. Means being a business commerce student, you are supposed to know when a company selects. In the beginning, in our first class itself, I said the very objective of this subject is to provide you the knowledge of provisions of Companies Act with regard to the business entities. Okay, legal provisions relating to the companies to provide legal knowledge, to provide the information, legal provisions of companies as per the Companies Act to the budding entrepreneurs and businessmen. So you are supposed to know while preparing the Memorandum of Association, what each of the clause, what care has to be taken, what information has to be provided. That is what we are learning here. So name clause, we said. Name clause means it tells about the name of the company. Under that clause, it tells what is its name, what is its logo, what is its emblem, what is its tagline, nature of business. All these details will be given. But while giving these details, one should remember a company like I'm so sorry, children. These bullets has changed the sentence because after preparing PPTs, I selected the design of the PPT slides. That's why these sentences changed. I'm sorry. I'll make changes. So, name clause. What this name clause says? Name clause says a company about the name of the company where upon which it is going to do its business. Okay. Generally, while selecting the name of the company, one should remember it should not a name of company should not resemble the other company names. It should not be similar to or identical to the existing company names. And next, similarly, logo. Logo also comes under the company's name clause. So logo means company emblem or say different some M or tick mark. Tick mark is for Nike. M is for McDonald. So like that, some logos, some emblems. Looking at that, we used to identify this particular logo is of this company, right? So these logos also not supposed to be identical or similar to the existing companies. So while selecting the name of the company, under the so name clause tells about name of the company, logo of the company, and the nature of company, the business which is going to do. Okay, because are you into manufacturing, or are you into trading, or are you into logistic management? So that nature of business also to be mentioned. Reliance Industries, again under the Reliance Industries there are various activities are there. Reliance Petroleum Industries. So what is this? Mining, right? Telecom industries. What is its work? It is into communication systems. So, like that, the nature of business has to be mentioned. The logo or emblem, but it should remember it not be similar to. One more point is that the Companies Act says name of the company. For private companies, name of the company must be suffixed with name with the term private limited, means Reliance Industries Private Limited, Tata Communications Private Limited. Like that, if it is a private company, their name should end with the term private limited. If it is a public limited company, their name should end with the term public limited. In previous class, we discussed about various private and public limited companies, right? If you notice, at the end of every private company, that these terms, private limited, you will notice. If you see BHL, Bharat Heavy Electronics Limited, HL, Hindustan Aeronautical Limited, ECL, what is ECL? Electronics Corporation of India Limited. So these are public limited companies. So they are ending with the term only limited. Okay. So if in case of a one person company limited, at the end you should mention OPC, means one person company. Okay. Now our next clause is that registered clause or situation clause, means this clause tells about the location registered, the location, address and location of the registered office of a company. Actually, under this company, when you if you are starting a business, you are supposed to give where your office, registered office, is going to be, the address along with the detailed address you are supposed, and your office address comes under which jurisdiction, means for legal proceedings if in case. This has to be given under the situation or registered clause. Now, for giving that, we should remember these points. What are those? So, while giving the registered office details, one should remember these points. First one is name of the state in which the registered office is located. Next, company within yeah. Within the 15 days of the incorporation, every company must have their office in that address. Why? Why that address they should mention? So that based on this address, the further communications and notices will be served. Next one is they should send this. So once they give this detail, what the registrar will do? Registrar will make the verification and Means 30 days. Within 30 days of time, registrar will do the verification whether that in that registered office company has located its business or not. Okay, like residence proof, like how you get a verification like that. So within 15 days of incorporation, whatever the registered office address given in that company should open its office, and within 30 days of incorporation, registrar will make the verification to confirm about the existence of a company's office in that registered address. Okay. Yes. In the address, so every company should not only that, whatever the address is there, that upon every communication, any sort of communication, you should mention its address. So name and address of the company a company must look inform or mention in every communication, especially official communications, wherever it is due, letters, emails, whatever, everything that has to. That is the reason why we see in everything. You will find a company's address in two place or from place, or even they are supposed to keep a board also in front of their office, a big visible board with the name of the company and address that we used to see. That is not only for the purpose of telling about their informing about the business located in that area to the customers. It is also important for the purpose of legal reasons. Okay. The next third clause is object clause. Object clause is what? Object clause is that just before I start this object clause, and small request to Ambedkar University technicians. I need 5 minutes. Please don't disconnect the line. I need 5 minutes. Please give me 5 minutes to conclude my class. Object clause. The third important clause is the object clause. This is the clause which is means every clause important. Apart from this, this is the main clause which upon which, because upon based on the the objectives it mentioned is going to perform its functions. It is going to design its structure, and based upon which the stakeholders are going to come forward to invest on the business. So object clause, it has various objects like primary objectives, secondary objectives, like that it have different objectives. But this objective clause again enables the subscribers. I told you, subscribers to know how their investments are going to be put, and extend the protection to the shareholders, and enables the creditors and other peoples dealing with it to know permitted range of companies' activities. So this is okay. So objective clause. Why objective clause to be given in the memorandum? Put a question for this purpose, because under this object clause, company is going to mention what are its objectives, how it is going to function upon, what it wants to achieve, what is how it going to perform. Okay, so this primary objectives, secondary objectives, and objectives which do not come under the above two. These are like that. Three types of objectives are there. So why they give this so that looking at these objectives, subscribers, that means shareholders, prospective shareholders or investors, will come to know how their investments are going to be used by the company, and what extent the company is going to give protection to them. Next, even the creditors and other people, whoever deals with the company, and to what extent, what is the scope of company and its activities. These all details can be known by the people through the object clause. So object clause tells about the objectives of company. Then liability clause. So what is liability clause? Under this clause or the content, company tells about the liability of its members, like whether company's members liability is limited by shares or limited by guarantee. All the details are to be. Generally, we about this also we learned in our previous class: limited guarantee, limited shares. Okay, so this again, this information also people use before investing in the company. Next one is capital clause. Yes, this capital clause, under this again, under this clause, company will give the details of a capital. Means what is this total amount of capital required in the for the business? The total capital required in the business is said to be authorized capital or nominal capital or registered capital. With this amount of capital, company will get incorporation, and it's not necessary that company issue the entire capital at a time, raise entire capital at a time. Whenever required, it will raises. But the total capital or authorized capital, it has to give. And the types of shares, what types of shares company is going to issue, the details of the types of shares, and the value of each share, how much it is going to fix. Then what are the rights it is going to, what are the rights under each type of shares the shareholders are going to get. Okay, all these details are supposed to be given by the company under the capital clause. So capital clause tells about the details of a capital, share capital of the company. Means what is the amount of share capital, how many types of shares is going to raise, what is the share value, what is total authorized capital, what are the rights of shareholders under each type of shares it is going to issue, all these details. Finally, association clause or subscription clause. What does it mean? See, till now, under this document, what are all details company has given? About the name of the company, registered office of the company, and objects of the company on which it's going to work, and then liability of its members, and the capital of its business. So these all details who are preparing, some directors are the people who are involved, who take the lead. Okay, board of directors or whoever the people involved in this. Then they are supposed to sign now. So this is the, so in future, if anything arises, there should be some responsibility. So some person should be there to witness or to say, authenticate. So this under this clause, the subscribers of memorandum is the people who are prepared, who are involved in the preparation of all these details, giving the detail, all these details in the memorandum, has to sign. And they are not only that, they should give their willingness to act as the directors of the company in writing. They're supposed to give their willingness in writing to act as the directors of the company, and they should sign upon that. In case of a public limited company, 7 directors has to sign, subscribers have to sign. In case of private company, 2 has to be signed. Okay, and after signature of these subscribers, even one more person also has to be signed, that is witness. Who is going to be the witness? Generally an advocate general, or the person advocate who is a like a high court or supreme court advocate or advocate general, like that. Not advocate general, I'm sorry. Has to be signed. Witness, a person has to sign a witness signature. So with this all details, the registrar will submit the memorandum of association along with the other documents. So memorandum of association is one of the important document which gives, which tells to the public about the company. Okay, so it has to be prepared with the utmost care and concern, because alteration of this document is very expensive. Not only that, the company is going to get the prospective customer, investors or subscribers based on the details given in this document. That's why it has to be prepared very carefully, and changing involves lot of efforts. Again, that's the reason why it should be careful. That's about Memorandum of Association, one of the important documents. After this, we have Articles of Association and their alteration. We discuss about these things in our next class. Thank you. Oh, I didn't take the photo of it. Okay. Thank you all. Thank you for your attention. Now I'm unmuting. If you have any doubts, you can unmute your mic and can speak. Yes, Sai Kiran would like to speak.
No, madam. I'm listening first class, madam. I don't know about subject.
Okay. How did you feel today?
I'm listening first class now, madam. I could not tell anything, madam.
Link, na?
Yeah, madam.
There is no link with the previous class and today's class. Today we discussed about incorporation of company and memorandum of association.
Okay.
How did you feel? You understood? Did you feel?
Madam. Little bit listening first class now, madam. Just now I'm just listening means don't nothing understand means just to listen first class now, madam. Oh.
Okay. You don't miss the classes. Yesterday, why you didn't attend the class?
Today only started now, madam. Class. Yesterday also have, no?
Also, we started. Yesterday itself, we started.
I don't know, madam.
Classes has been started.
Miss the classes. Try to continue the classes regularly. Okay.
Okay, ma'am.
Anyone else wants to speak? May I get the feedback?
Okay, ma'am.
Tomorrow we will discuss about articles of association. Na?
Yes. We have next Saturday and Sunday. That is on 12 and 13, I hope.
Okay, ma'am. Thank you.
We have next class on next 12th and 13th. Next Saturday and Sunday, 12 and 13. Same timings.
Okay, ma'am. Actually, Ambedkar has not tell me, madam. Yesterday as class have, so do not know, madam.
Actually, about that we have no idea. How you get, but it's sent without sending the information to students. How can they start the classes? You might have received, or your number might have changed, or you might not overlooked. Something might have happened. Please look into that, because all students, without students, they cannot conduct classes, right?
Okay.
Some arrangement they might have done.
Message, ma'am.
Anything else?
On 4th only they have message, ma'am.
Can we wind up? Yes. Can we wind up our class?
Okay.
I think. Right. Thank you, children. Thank you for here.
Thank you,
We'll meet our next class.
Yes, ma'am.
Okay.
Yeah.